The gentleman yields back. Appreciate your testimony. I'll now recognize myself for the purpose of questioning our witnesses. I want to start with you, Mr. Adams, if I can. I think one of the questions is, what is the federal standard and what is the role of the federal government in making sure that states are maintaining their voter rolls? And so if we go back and look at Section 8 of the NVRA, states are required to, quote, conduct a general program with reasonable effort, end quote, for voter list maintenance. And then the question would be, how does the courts interpreted reasonable effort? Can you give us a little color as to what is reasonable effort according to the judiciary?
Well, that's a terrific question because as it stands right now, it just means make an effort. You got a participation trophy, right? If you do something, you succeed. But look what Congress passed after a reasonable effort. In the language of the statute, it says to remove. There's actually an action verb, isn't there? It's not just make an effort, it's actually have to do something. And I think that's what the courts have improperly focused on.
And is it true in a court that, in a case that you were involved in litigating, the court came back and said that the reasonable effort is such a low standard that as long as one deceased voter is removed from the rolls, they've met their Section 8 obligations?
I think it's worse than that. As long as you have a program and you're doing anything, you satisfied what Congress tried to do.
So what should the standard be, knowing that the courts have effectively gutted out what I view as a reasonable standard? From a general program, should be something more specific. How do we redefine this to make it so that states actually have to do their job of maintaining proper voter rolls?
Yeah, the NVRA reads like a negligence statute, but in HAVA, the Help America Vote Act, there's strict liability. If you have any problems on the rolls, then you're violating federal law. The problem is only Attorney General has the right to bring a lawsuit. There's no private right of action in the NVRA.
I want to continue with you, Mr. Adams. So in the NVRA, are there restrictions on who can be removed? So if you have an individual, say, that's not a U.S. citizen, this has come up, what are the restrictions on states from removing someone that they deem to be ineligible under the NVRA?
There really isn't a restriction on the state to remove a non-citizen. They have that freedom under our Federalist arrangement. The NVRA, however, doesn't reach non-citizens, meaning we can't bring a case to remove non-citizens under the NVRA. We tried. We found out the hard way it doesn't fit.
So you don't have standing to go and do that. Who would have the standing to do that?
The Justice Department would potentially under HAVA, but Congress could expand the NVRA to reach non-citizens. That's easy. It's hard to imagine anybody would vote against that.
And so let's then maybe look at the state of Illinois. We know that according to the DOJ, 34 counties in Illinois provided no evidence of voter list maintenance. So the DOJ can bring forward that claim as they are in the Trump administration. But if you didn't have the Trump administration, it would simply be ignored because no one else would have standing, knowing the state is unlikely to go after itself.
Correct. You need somebody with the power to do something about it.
So if you have a completely Democratic state like Illinois, they're not going to move forward on this. If you have a Democratic administration or the Biden administration, they look the other way. We could get into a gerrymandering discussion with my colleague who was referenced in the opening statement. You want to look at a casebook study, I'd recommend looking at the congressional lines of Illinois, led by a fully Democratic operation, but that's not the point of the hearing today. But if we look at that, is it really but for, thank goodness, the Trump administration coming in and a Pam Bondi-led Department of Justice, that otherwise the state of Illinois would not be under any sort of review?
Or make it the state of Michigan. That's the real-world example where the Secretary of State there has done nothing for a long time.
Well, we chatted with her in this exact hearing room not that long ago, specifically about the poor voter list maintenance in the state of Michigan. But you bring up a good point. In what scenario can a state remove a voter who has moved?
Well, that's a tough one, and Mr. Reamer talked about a bit. The NVRA has hurdles, statutory hurdles that they have to go through, like waiting, and it's all based on this technology from 1993, like the postman, right? And so the postman is given the power to keep our rolls clean or not, and really there's technology out there that this Congress could address.
So let me jump over to you, Mr. Reamer, if I can, in my time left. How about public access to voter rolls? In the state of Wisconsin, public access is available. Is public access available in Virginia or the other 49 states around the country?
Yes, Chairman. It's available in every state that's covered by the NVRA. And I know Mr. Adams.
But are there restrictions on people obtaining access to those voter rolls?
States impose restrictions that the NVRA prohibits.
What would be an example of that?
Not disclosing records concerning their basic list maintenance activities. They put walls up, they delay, they try to charge you more. all of these things. And the NVRA was designed to allow the public to audit state list maintenance activities. That was absolutely contemplated when the law was passed, but states just put up barriers.
And I think what we see is time and again, states failing to do their job as Congress directed in the NVRA. We see courts weakening the standards of the NVRA. And I think it's absolutely imperative that we improve the process in which voter list maintenance is occurring. Cognizant of the time, I will yield back and I will recognize the ranking member, Mr. Morelli, for 5 minutes for his questions.